All right, class. That's our introduction for contracts. You ready? 3, 2, 1, contracts. Let's make contracts. They're fun. They can be fun. They're interesting. And it's how we do business. And I get very excited about contracts because when I was in law school, they just sort of clicked for me. And I realized they're all around me. I've been making contracts ever since I learned how to communicate, whether it's with my family, my friends, schoolmates, teachers. We're making contracts as a class. We have contracts with the TC3. You have contracts with TC3. I have a contract with TC3. There's contracts all around us. You wake up and you start making them. You start carrying them out. You cancel them. If you've ever broken a promise or one's been broken on you, you know what a breach of a contract is. So today's lesson in chapter 8 is introduction to contracts. And then the rest of the semester, we're just going to be talking about all the different aspects of contracts and getting really in detail with them, looking at them from different angles, from the beginning of a contract to when it's being performed or not performed or breached, what happens at the end, how to discharge. Those are what the rest of the chapters cover. But our role in modern society depends on contracts being enforced. So, back to chapter 1 and the functions of law. We want our government to help us enforce contracts when there's breaches, for example, or we want to help the government to help enforce contracts so that they're not breached, so that they're not broken. And, I think you'll get an appreciation of the role of contracts in business law, because it really is the fundamental topic that we've been working our way into. We talked about the social contract theory, our contract to give up some freedoms in order for the government to have a government that accomplishes those functions that we talked about in chapter 1. And in the United States, I would say, there's no part of the Constitution that really says explicitly that we have a right to contract, but it is fundamental in there. We have life, liberty, and the pursuit of happiness. Well, the pursuit of happiness depends on contracts. And to some extent, liberty is the freedom to create contracts, to do business, and for the government to support us doing business. And it all relies on contracts. So what is a contract? Basically, it's a legally enforceable promise. And not every promise is legally enforceable. So we're going to, learn about different kinds of contracts. Sometimes they can be unenforceable, for example, or it's illegal to enforce them, for example. But basically, in order for capitalism to exist, we need contracts to be enforced. So that's one of the limits of when we say capitalism is, just laissez-faire. Fundamental to capitalism working is a government that can enforce contracts in our court system. So a contract, another way to look at a contract is a meeting of the minds. Okay, first I want to go through two definitions in the law that we're going to be referring to a lot, which is the Restatement Second and the Uniform Commercial Code. We'll go much more into those later. We talked about sources of law gradually coming into chapter 8, and now we're going to focus on when it comes to contracts. We generally look to the Restatement Second and the Uniform Commercial Code. And those are evolving laws themselves, just like all the other laws that we've been talking about, and they apply particularly to contracts. The Restatement Second defines a contract as a promise or set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes as a duty. So we talked about in chapter 7, when we talked about torts, we talked about existing duties. You have to prove that a defendant had a pre-existing duty before you can sue someone for a tort. So here we are again with the concept of a duty. And those are spelled out in contracts. That's one of the basic concepts that we're talking about, is a duty under a contract. You have to understand what that means. Now, under the Uniform Commercial Code, which I'll probably just be calling the UCC from now on. So we've got the Uniform Commercial Code, the other body of law, and we're just going to call that the UCC. That's the acronym for Uniform Commercial Code. And that is the total legal obligation which results from the parties' agreement as affected by this act and any other applicable law and rules. That's how the UCC defines a contract. And back to what I was talking about, the meeting of the minds, I think that's what lawyers like to refer to as a contract, because it illustrates what a contract is once we start to uncover the different elements of a contract. So, you know, I talked about how the rest of the chapter, we're going to look at contracts from different points of view, because right now we're doing an introduction, and I can basically just teach you concepts and vocabulary pretty loosely. Until you start to see contract disputes work themselves out in the court system with the cases we're going to study, I think it's hard to really see a contract and how they work from 360 degrees. But by the end, hopefully it'll click, and you'll look at contracts in a different and momentous way, like I do. And it could happen some point before we get to the end of the semester. You know, it happened to me when we studied what's called consideration, and we're going to hit that at chapter 11. And until then, I mean, I sort of understood what we were covering. Once I understood consideration, though, and basically consideration is what you pay for the benefit of something. So a contract is generally quid pro quo, you know, this for that. And consideration is the this for that. And in United States law, we have to have consideration. Now, that's a US concept. It's not, that law isn't recognized all around the world or in history, but in current US law, and since the foundation of our country, consideration's always been a requirement. We'll get to that in chapter 11, as well as, let's see, some of the other things we're gonna talk about are mutual assent. That's our next chapter, in chapter 9. And that's offer and acceptance. So one thing basic that you need to know for your next exam and forever is a contract requires an offer and acceptance. So it's at least two parties, and one of them made at least one offer, and the other party accepted that offer. That's a meeting of the minds. So basic understanding of a contract starts there, is that you've got offer and acceptance. Then in chapter 10, we're going to sort of look at that a little bit deeper and say, is there real assent? Assent being agreement. Is the assent real, or is it maybe illusory in some way? Is it fake? Is it been coerced? Things like that. As the person made some mistake in going into the contract that needs to be remedied by the law. Has there been misrepresentation or undue influence? That's what we're going to get into in chapter 7. I talked about consideration already in chapter 11, legality in chapter 12, and then 13 through 16, we're going to talk about third-party rights and remedies, discharge of contracts, some of the things sort of on the back end of contracts. And let's see, with sources of the law, I talked about those two major ones. We've got the UCC and the restatement second. And basically, the contract lawyers in the United States were having to go to these books. You know, imagine just libraries full of books, all about contracts in different states, and you know, there were just published opinions all over the place. So what the American Law Institute did is they formed in 1923, and that was a group of lawyers and judges and scholars. And they said, let's boil this stuff down and look at it scientifically. Let's look at the study of contracts and come up with a book so lawyers and judges can refer to this source of law. And that became the Restatement of Law in 1932. Then in 1979, they republished it, and we have the Restatement Second, because a lot of law changed over those 50-ish years there. and they published the restatement second, and that's what we're working with today. Then we've got the Uniform Commercial Code, or UCC, I talked about. And again, we had the American Bar Association, which is a voluntary group of lawyers and judges all around the country. And they decided, hey, we need some basic rules that our clients, businesses, can understand as the sort of default rules when we're making contracts under certain circumstances. So it strengthened the relationship of businesses between states because there were certain basic principles about, for example, when a contract needs to be in writing. Because, you know, that's something that I think people assume when they hear about contracts and they haven't studied contract law. They believe that contracts need to be in writing. The contract is a piece of paper and it's signed by both parties, for example, or it's notarized, or it's signed in someone's blood, or whatever it is. That's not the case. The UCC, though, does give us some rules, and also that concept of having to be in writing dates back to England many, many years ago, called the Statute of Frauds, which is something we'll spend more time on later. But basically, that's the concept of when a contract has to be in writing, is the Statute of Frauds. And that's an old statute. It's not in place anymore, but the UCC gives us guidance on when things need to be in writing, and that all businesses in the United States play by those rules. The UCC is that rule book that attorneys tell their clients that you have to follow. So it also allocates risk in certain situations, but we'll cover it more. There's general provisions. It's in chapter 8.1. It goes through the different articles of that. I don't really think you need to know what each article is of the UCC. So you don't have to worry about that so much. But you know where to look. All right. Now, the UCC also is developing an international version. So that's helping businesses do international business and have certain ground rules that will apply. Now, it's a series of, back to the UCC, the UCC, even though every state has adopted the UCC, new rules come out. And so lawyers have to pay attention to which states have adopted the UCC. So this isn't a law that's been gone through Congress and signed by the president. It's a body of law that was adopted by all the states. So if you think about how laws are created, this is a new and innovative way that a law was created. The UCC was adopted by all the states, and it didn't have to go through Congress or anything like that. But internationally, we've got a similar situation. So in 1980, there was a convention on contracts for international sale of goods, and that was in Vienna, Austria. And the US plus more than 40 countries are part of it. And like I said, consideration, for example, is not an international concept that's that's needed to enforce a contract like it is in the United States. So, the UCC is going to be a bit different when it's applied internationally, but it's a good place to go if you're thinking about doing business internationally. Maybe you've got a factory in Honduras, which is going to be able to produce your product at 1/10 of the price that it would cost to produce in the United States. And, bottom line, that's just so much cheaper. And maybe, hey, you like Honduras and you want to support their economy, and we have a free country and it's capitalism, you can do that. But what you're going to want to do is get an attorney who knows what Honduras's relationship is with the UCC, the international UCC. All right, US treaty power, just keep in mind that preempts the UCC. So, depending on if something's adopted in a certain way and there's a treaty that interacts with it, again, it's not a statute. So whereas treaties and statutes have that last in time rule that we covered in chapter 3 or chapter 4. It's going to be different because the UCC's adopted a different way. Now, it's not mandatory where choice of law is explicit in a contract, so you can sort of put that, you can bypass it. It's the default rule of law that has some basic ground rules for business and contracts. All right, contract law, it's just some general concepts. We're going to get into these much more in depth as we look at each of the different topics covered in the chapters. But one, when it comes to introduction to contracts, we have to discuss is explicitness. So in a contract, it must be an express contract and things have to be spelled out directly. So for example, we agree, maybe even on the phone or by text, maybe not in writing, but that you're going to deliver a used car to me and it's $5,500 and you're going to bring the car and the title to me on Monday at 11 a.m. That would be explicit. It's very, it's clear to both parties, what is being sold, how much the price is, when it's going to be delivered, and what is going to be delivered. Not just the car, but the title. That's one example in the book. Another type of explicitness can be implied in fact. So, for example, if you go to Wendy's and you order a chicken sandwich and the cashier doesn't tell you how much it costs until the end, it's rung up. Or I guess that's a situation where it would be explicit, but think maybe a restaurant where you order a chicken sandwich and the waitress comes and delivers you a check at the end. Well, that's implied. And that's where, it's general custom that you agree to pay how much the item is on the menu and you'll pay the bill at the end of your meal. So that's an example of that. We've got quasi-contracts, or ones that are implied in law. And that is sort of a concept where, let's say, someone delivered a bunch of materials to your house to build a porch. And you said, I didn't order anything like that. And you didn't tell anyone about it. And you went ahead and built the porch. Well, you don't get a free porch out of that. That's what's called unjust enrichment. And so generally the court will find, even though there was no contract or duties or obligations agreed to by anyone, you were delivered the wrong delivery. And, the proper thing to do would be to say, oh, who delivered this? There's a receipt on here. I'm going to call them and say I didn't order this. That's what a reasonable person would do. So if you, went ahead and built a porch, a court could find a quasi-contract there. So that's getting into a bit of the outer space of contracts. So we're going to bring it back to introduction and talk about mutuality. And that is that contracts generally are between two parties, and there's usually some mutuality going on, quid pro quo, this for that. And that would be a bilateral contract. Okay, and those are going to be pretty simple to identify, simple to enforce. Then we have what's called unilateral contracts, which can sometimes be enforceable contracts, even though it's one person putting out there an offer. It can get a cent out there and be enforceable, even if maybe the two parties aren't known. We'll get into more examples, but the one I think that's identified in the book at this point is pretty simple to understand. And that is if someone puts an offer out there about their lost cat, and they say that if someone returns their lost cat, they're going to get $100. That is a unilateral contract that's out there, and that offer can be accepted, even though the person didn't identify who they're making that contract with, okay? Because they don't know where the lost cat is. but they're putting that out there as a unilateral contract, and that's going to be enforceable. It's similar to businesses when they advertise, and we'll go into some unilateral contracts involving advertisement. But that can be an offer, and there can be someone who accepts it. And even though the person didn't know who they were making that contract with, the contract is enforceable. So that's the difference between a bilateral contract, a unilateral contract, and how there's mutuality under both of those situations. All right, and the third topic covered in the basic parts of introduction to contracts is the enforceability of contracts. So a few concepts to define there. We've got contracts that are void. In other words, they do not exist. They are void in their nature, and not every agreement is binding. So for example, if someone hires a hitman to kill somebody, that contract is not enforceable from the beginning. It's illegal. So we'll talk about contracts that are illegal, and those are generally void. But then there's a class of contracts that are voidable. In other words, they're not void per se on their face from the inception, but maybe one party can choose to void a contract. An example of that would be someone who is incapable of making a contract. For example, if you're under 18, or if you have, if you're intellectually disabled and someone knew that, or if someone's intoxicated. Generally, those contracts can be voidable, but they're not necessarily void. So if a 16-year-old buys a car and the person who sold them the car doesn't bother to see if they're over 18 and they can actually agree to a contract like that, the 16-year-old, the contract's not void at this point, but the 16-year-old can void it. They have the ability to void that contract. It's not void, it's voidable. That's sort of the difference between void, hiring a hitman, voidable, a 16-year-old buying a vehicle. Now there's exceptions to everything I'm talking about, but we'll get into those details in the next few chapters. Then we've got unenforceable contracts. So for example, if someone owes a debt and then they go to bankruptcy, well, the debt is essentially canceled in sometimes in those situations, or there's different types of bankruptcy. We're not going to get into bankruptcy much in Business Law 1. Just an example, you can, I think Business Law 2 covers it a lot, but just something to keep in mind when it comes to contracts. It can make a contract unenforceable. All right, we'll get into the degree of completion of a contract. So, you know, contracts, sometimes they're partially performed or they're not performed at all. We'll spend some time on that. When we're talking about contracts, we're going to talk about some terminology, and that terminology is, there's a good list of those words on 289. So depending on the kind of contract, I might be talking about a promisor, promisee, or when we're just talking about the concept of a contract offerer, offeree, obligor, obligee when it comes to an obligation. If there's a transfer, we'll be covering that in third-party rights. And that we would call that a transfer, transferee, assignee, assignor. There's mortgages, mortgager, mortgagee. So that vocabulary is worth taking a look at on page 289. And it might be a good spot to test on too, but there's a nice list there. All right, so nice short introduction to contracts. We're gonna next talk about some cases, because like I said, I think in order to really get that click about how contracts work, I think that it just takes exploring the cases that we're talking about and the history of contracts and what we think about them. So the first one has to do with explicitness and an implied contract. So this is where something's not quite explicit, but it may as well be. It's implied contract the court found out. This is Rogers Backhoe Service versus Nichols. And we're talking about a crematorium being built by a funeral home. They already have the funeral home and they want to expand and do, cremation of remains. And they have to get a permit for that, which is normal when it comes to construction. If you have a business and you want to build something, especially if you're in a city or a village, they're going to have some code. You're going to have to get approval from the municipality, and that's what's going on here. And Nichols made a contract with Rogers Backhoe Service to build this crematorium and also the parking lot and everything along with that. And the city said, well, your drain, your runoff, your water runoff, we want you to use the sewer that's underneath the property. Now you're going to have to dig a bit to get in there, and we're actually not sure it's going to work, but that's what we're approving. And so Rogers Backhoe Service went ahead and did the exploratory digging. And basically the engineers agreed, both for the municipality and from Rogers Backhoe Service, that it was not practical to use that channel that they dug to have the water runoff go directly in the underground sewer system. And instead, they were allowed to fill up that exploratory dig, build over it, and use the existing drainage that to the sewer that was available, run off into the street and the other channels that went into the sewer system. So that took, though, a few days of labor for Rogers Backhoe Service, and the city ended up saying, you don't need to do that. This is Muscatine, Iowa, the city. And so Nichols, who owns the crematorium, said, well, we don't want to pay you for that. That was completely unnecessary. That was not part of the contract, and you didn't have a duty to do that. We didn't have a duty. And the district court, the trial court, ruled in favor of Rogers. And then the appellate court reversed the lower court and said that there was no benefit to Nichols in the case. And so their reasoning was that ultimately they didn't need to have that channel that was dug. So that's on Rogers Backhoe Service. Well, they appealed to the Supreme Court of Iowa, and they gave it another look when it comes to contract law. And they said the party seeking recovery must show, 1, the services were carried out under such circumstances as to give the recipient reason to understand, A, they were performed for him and not some other person, and B, they were not rendered gratuitously, but with the expectation of compensation from the recipient, and 2, the services were beneficial to the recipient. Now let's look at the facts in this case. The way the intermediate court decided, they recognized that Nichols didn't actually need that hole dug. But what the higher court realized is that there was a stalemate between the city of Muscatine and Nichols, that they couldn't finish the construction and get that permit, but for the exploratory dig, which Rogers Backhoe Service had to do at the direction of the city. So the Supreme Court reversed the appellate court and upheld the decision of the lower court in favor of Rogers Backhoe, saying that, in fact, their customer, their client, the crematorium, did get a benefit. They didn't ultimately need that channel, but it would have been a stalemate if it wasn't for that part, if it wasn't for the performance of that duty. So they found an implied contract there, and they enforced it. All right, the next case involves mutuality of a contract, or a unilateral contract. And this is South Trust Bank versus Williams. And Williams is one of two people in the case who had a overdraft account. Okay, so what they would do with these overdraft accounts is they would there was an agreement that they would pay off larger draws before the smaller draws, which increased the number of overdraft fees. So now after this case, this case is from 1995, and the appeal, it ultimately is decided in 2000. It's from Alabama. And since then, what you should know is that banks have a duty to they might not be able to make these kinds of contracts. So this is the kind of contract that's fine print that a lot of people don't read. And of course, this practice, like I said, might be outlawed to some extent because of reforms, because of cases like this. But back then, basically, this fine print had said that there was the larger draws were paid off before the smaller draws. So if you went out and you had $400 in your bank account and you made, let's say, 4 purchases, and the first one was for $300. So you bought maybe a television set for $300. So you have $100 left. And then you go out and you buy a table for the television set, and that costs $60. And then you've forgotten how much you've spent, and you think that you can still afford to buy a video game console or something, and then that's $100. Well, now your overdraft, you're paying overdraft fees on top of that. Your bank makes up the difference, but you've spent more than your $400, and you're going to incur an overdraft charge. And then you go get a cup of coffee, and maybe that's $2.50, but it gets, a $30 overdraft charge, because it's, again, you charged into your line of credit, your overdraft to your account. And then maybe you get some sandwiches later, and whatever, you make a few small purchases. Well, what they should do to help you as a customer is, let's take that $400 and let's start with a cup of coffee, so we knock off the little charges, so we're not building up all these overdraft fees. But instead, in the fine print, it says they're going to pay them off, the large ones before the smaller ones. And yeah, if all that cup of coffee, that sandwiches you made, and the original overdraft, those each are going to have their own overdraft fees in the scheme that's going on here. So some attorneys decided, we're going to sue them because that is unconscionable, that is not enforceable. And in a sort of common sense way, or if you aren't a big fan of big banks just making a bunch of money off people, you might side with the account holders here. However, also in that contract, we need to pay attention to arbitration clauses. And courts really like arbitration clauses because it's something in a contract where someone's agreeing not to go to court. So courts are going to like that. That's less work for courts to do. It's like, hey, try to work it out in arbitration. Don't file a lawsuit all the time. And courts will enforce that. And that was in this contract. And that's what the court decided in this case, is that there was an acceptance of this arbitration clause, and we're going to go ahead and enforce it, even if we don't like the banks doing this. All right, so something to keep in mind, that if in a contract there's an arbitration clause, it's public policy to enforce those. We don't want to overload our courts with lawsuits. So those are popular, and you're going to have to look at those and abide by them. Now, the next case involves unilateral contract and at-will employment. So this is the case of Willie versus Hoffman-LaRoche, and it involves an employee handbook. So I think we've covered it in the class already, but doesn't hurt to look at it again now, that employment in the United States is generally employment at will, especially certainly in New York State. And other states, maybe a bit more progressive, are developing different laws on that. You look at Europe, and I wouldn't start with employment at will. You've got some basic employee rights in a lot of countries, but not in the United States. Generally, we're employment at will. That's the general common law rule here. And what we have in this case is we have the plaintiff, Willie. He's been working for this company, Hoffman-LaRoche, for a while now, and he was given a handbook, and it's an 8-page handbook, and there's all kinds of ways in there that you can get raises, or you can be promoted, or you can be disciplined, or you can be terminated. However, it doesn't say, it talks about retirement, things like that, bonuses. However, it doesn't say anything about being terminated for no cause. Okay, so the general law is that we've got employment at will. So people can quit a job, or they can be fired, they can be terminated, and there doesn't need to be any kind of cause for that. However, there's a unilateral contract like I talked about here. Arguably, the employer gives the employee a handbook. Here's our policies. Well, the plaintiff in the case relied on that handbook, and he got promoted a few times. Then there was some duty that he had to do involving a pipe design report. Okay, so he's promoted twice, and they're relying on him to do this report about pipe design. And they get the report, and they don't like it. They say they've lost confidence in him. There must have been something in the report that hurt their bottom line or something. I don't know the details about that. But they went ahead and asked him for his resignation. He refused to resign. He said, I haven't done anything wrong. I did my report, I'm doing my job, and I don't think I should have to resign. So he doesn't, and they terminate him without cause. So they didn't follow any procedures in the handbook. They just relied on the common law that employment is at will. Well, the trial court went ahead and granted a motion for summary judgment. So the attorneys appeared, they traded discovery, and then the employer filed a motion for summary judgment saying that, hey, we don't need a trial because this is a well-settled area of the law. Companies can terminate people at will, employees can quit at will. And the lower court said, yeah, you're right, we don't care about this employee handbook. This was just nice of the employer to give to their employees, but it didn't create any kind of contract. Well, the appellate court affirmed that decision. However, it went up to the Supreme Court, and the Supreme Court basically made a big precedent here, saying that employee handbook, where employees reasonably rely on that handbook, creates a contract. It was unilateral when it started, but once the employee decides to get the incentives in the contract, to get bonuses, to get promoted, you've got give and take between both sides here. What the court said to the employer was all you had to do was put in that employee handbook somewhere in those 8 pages, just say that nothing in this handbook interferes with the common law or with the basic law that this is employment at will. So unfortunately, the plaintiff died before his case got appealed, and didn't, he thought he lost he lost his job and he had no recourse, but his family benefited from it. But just a little side note. And so if you ever get an employee handbook, you're probably going to see a line in there saying that this is employment at will. And then they're covered under this precedent. All right, well, that's just the introduction to contract law. It's going to get even better from here, and I hope you enjoy it. Bye for now.